Hey, this is Mike Otranto. Thanks for visiting my YouTube channel. I wanted to go over in this video the basics of a lease agreement, some of the standard clauses that are in a lease agreement. Now, I did do another video on there's no such thing as a standard contract, but if you get a lease agreement, especially one from the various apartment associations, also, even if you went online and you Googled a state lease agreement based on state, so North Carolina lease agreement, New York lease agreement, something like that, there are several clauses within the lease agreement that will be pretty consistent from state to state. And the first one is going to be when rent is due. Also, how much a month per rent will you pay? And the benefit to this, both for the tenant and the landlord, is that once that rent amount is set in the lease agreement, that rent amount cannot be raised. So as a tenant, I'm assuming you don't want your rent raised every month. So if you do, let's say, a 12-month lease agreement, your rent cannot be raised during that 12-month period. So usually on the first page of a lease, you will have a legal description of the premises. You will have the address. You will have the name of the landlord, the name of the tenant. Keep in mind that everybody who resides in the premises must be listed on the lease agreement. Usually everybody over the age of 18 must be listed as a leaseholder, and that person will probably have to be screened with credit and criminal background check. I mean, that's how it should be. Also, anybody under 18 will be listed as an occupant. They won't have as many rights as a leaseholder will, but they still need to be listed because those are the only people that will be permitted to occupy the property. Also, on the first page, you will have the due date of the rent, which is usually the 1st. It will usually say that rent is due on the 1st. It is late on the 2nd. It will then say when a late fee will be assessed. Now, in North Carolina, you cannot assess a late fee before the 5th. I think most states will be similar to that. You would have to check your local state laws. More often than not, it's going to be no late fee can be assessed before the 5th of the month. Now, the late fee, the amount of the late fee must be specified. It cannot be arbitrary. So, usually the maximum is about 5% allowed by state law. Again, you have to check for your local state laws as to what is the maximum amount of late fee that can be charged. You also will see the length of the lease. Is it a 6-month lease, a 12-month lease, a 24-month lease? I mean, I've seen leases as long as 10 years. But I guess more commonly it's going to be a 12-month lease. Now, if you're going to do anything under a 3-month lease, that does require different rules and regulations, though. So also, you will have, sometimes you'll see how and where funds are to be paid, whether it's by check or money order, whether or not it's electronic, where you're supposed to pay the rent. Keep in mind that a landlord will usually not be obligated to come knock on your door and pick up the rent. So the rent will usually be said to be due without demand. So that means you are expected to pay the rent, usually at some kind of an office or maybe a P.O. box, or I've seen some businesses just have the tenant go and deposit the money at a local bank during business hours to a certain account. But usually per the lease agreement, this will be due without demand, so the landlord will not be expected to call you, knock on your door, so on and so forth. Also, if you have NSF, non-sufficient funds, or a returned check, it will list a returned check charge. More often than not, I see $25 as a NSF fee. Keep in mind, if you pay your rent even before the 1st and the bank notifies you that the check bounced and you are notified of this on the 7th, you will be required to pay the full month's rent, the late fee, plus the NSF fee. So you want to make sure that you have sufficient funds in your bank account before you write a personal check. Also, and this gets most people, most leases will go 12 months, and then there will be provisions in the lease that if you do not enter your notice to vacate or notice of your intention not to renew your lease, you will by default go on a month-to-month lease. So most of the provisions in the lease will stay in place with some exceptions. Your rent can go up with 30 days notice. If for whatever reason that you want to surrender the premises, you want to move out, you always have to give written notice. A phone call is not sufficient. Though most states will recognize an email as sufficient notice. Now, some leases will say you have to give us 60 days notice in writing if you don't intend to renew your lease. Some of the times it's 30 days. By default, on a month-to-month lease, it is 30 days notice in writing. Now, keep in mind that I've seen people get tripped up with this. What they do is they sign a 12-month lease, and coming about, let's say, 30 days out, 45 days out from the expiration of their lease, they call up the office and say, "Yeah, I'm going to be moving on this date." And if the lease says that you have to give 60 days notice in writing, until you give 60 days notice in writing, you're going to be responsible for 60 days worth of rent from that day. And usually what that means is on the expiration date of your lease, which is usually on the first page, you're going to be responsible for that monthly rent until the final day that's on that first page. Then for the remaining number of days, you'll be responsible for usually a month-to-month rate, and that is usually more expensive. That gets a lot of people. So you want to make sure that you read all these provisions in the lease. You should read the lease word to word, read it word to word, word for word, before you sign it. Now, I am not an attorney. If you need legal advice, you need to seek out an attorney, but you don't need, I wouldn't go to an attorney just to explain a lease agreement to me. I would read over the lease and then ask the questions that need to be asked, usually with the property management company. But most leases the clauses in there are pretty self-explanatory, especially rent being due on the first and late on the second and that kind of thing. Also, it will talk about premises are to be kept in clean and safe condition, that kind of thing. Repairs are to be brought to the attention of the landlord immediately. If this kitchen sink is leaking, you can't just let it leak and not say anything, because then you will be responsible for whatever damage is caused as a result of that leak. So, the owner will have the right to enter the apartment to make repairs. The owner will have a key to the apartment. You are not allowed to change the locks, that kind of thing. These are all pretty common in most lease agreements. Some of the other things might be to dispose of trash on a daily basis, not to pile trash inside the house. That kind of, draw rodents and other vermin. They might talk about pest control services. Also, whether or not you can have a security system put in. If you did have a security system put in, more often than not, you will have to give the property management company or the landlord the security code so that they may have access to make repairs, especially in an emergency. It might say things like you can have an overnight guest, maybe a maximum of 2 nights out of the week, that kind of thing, if you have a friend or girlfriend. And part of it, what we spoke about before, is no one really can stay in the apartment, can reside in the apartment that's not listed on that lease agreement. So some other provisions in there: move out. What is expected of you when you move out? And usually you are expected to return the apartment in the condition you found it, less ordinary wear and tear. Now, ordinary wear and tear can be a gray area. It can be interpreted differently. There are property management companies out there that want to nickel and dime people. Some of that is wrong. The only thing, if you have a disagreement with what you've been charged for by your property management company, basically you would have to go to court and have a judge arbitrate. The other thing that gets most people, and this is kind of negligence on the tenant, is that when you move in, you have a certain amount of time, usually 48 hours. If there's anything wrong in that apartment, if the carpet is stained or ripped, if there's scratches on any of the countertops or the windows are broken, you need to make written note of that. Usually you will be provided with a move-in inspection form, but the landlord, you really can't rely on the landlord to give you a move-in inspection form. You have to do your own due diligence when inspecting the apartment, ideally before you sign the lease. But you can sign a lease, let's say if you're moving from out of state, and then move into the apartment and then bring to the attention the landlord, bring to the landlord's attention anything that was damaged before you moved into the property, so that you will not be held accountable for that. Keep in mind, if, let's say, for example, the carpet was heavily stained and, I don't know, there were scratches on the cabinetry. If you did not make note of that before move-in, upon moving out, you would be responsible for that, regardless of whether or not you caused that damage. So this gets a lot of people, this does create a lot of confusion, but this is one of those things that you need to know about before you rent an apartment. And that's, for the most part, I mean, that's most common issues and concern with a lease agreement. If you want more updates, subscribe to my channel. You can call me. I answer my own phone, 919-667-6331. If you've enjoyed this video, please like it on YouTube. If you have any additional questions, you can call me. You can reply to this video with a question. I'd be more than happy to make a video in reply. Thanks for visiting my YouTube channel.